All right, I'm just kind of getting my signal right to go through these constitutional law note cards. Go through them and kind of place them where they belong in the outline. Outside, so it might be a little hard to hear me. Alright. So, try to order them, right? So, employment exception would go in the equal protection section of the outline. Alienage can be considered for state employment positions involving the self-government process. For example, police officers, primary and secondary school teachers. And this is because those roles are discretionary self-government process, and therefore those individuals of or an origin outside of United States may be taken into consideration in the state employment practices for hiring to those particular positions for police officers and primary and secondary school teachers. I have here the Judiciary Act. Haven't talked about in a while. So the Supreme Court shall have appellate jurisdiction from the circuit courts and courts of the several states in the cases hereinafter specifically provided for, and shall have power to issue writs of prohibition to the district courts when proceeding as courts of admiralty and maritime jurisdiction, and writs of mandamus in cases warranted by the principles and usages of law to any court appointed or persons holding office under the authority of the United States. So that's kind of like judicial power. Necessary and proper clause, more of a congressional power in the legislative branch to make all laws. Well, I might say this. The Judiciary Act, being an act rather than a constitutional law, like clause, amendment, or provision, even though much of that language sounds like it comes from the Constitution, being that it came from the Judiciary Act, potentially even Section 13 of that act, that actually was a congressional act. So might have derived from the legislative branch, but it pertains to the judicial branch. One of the early laws to try to set forth jurisdiction of the courts, of the federal court system. So in necessary and proper, this probably comes from the Constitution, to make all laws. So this is the Congress may make, or has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. So the Constitution goes in the order of now I don't remember. The outline goes in the order of judicial. So just placing these in order. Legislative is first, Article 1. Article 2 is the executive power. So it's leg, as I should have known. And the judicial powers are in Article 3. So I'm putting these in that order. Next note card is causation. Reading requires causal connection between injury and challenge conduct, probability calculation, and defendant must have caused harm traceable to the conduct. This might be an element of standing required for courts to hear a case. If causation, no, it's not actually. It might be a sub-element of standing. Section of note cards, the judicial branch section of note cards. Freedom of association. I have the right to exclude expressive association, not a small, from expressive association. When exclude, if it is an intimate association, not a family gathering, or an association, infringement of rights to require inclusion. The freedom of association, no, it's not. Freedom of 2, prohibitory laws and punishment. This is really, really hard to read note cards. I apologize, but it laws restricting it or asking associations to like provide their list of members, for example, is subject to a strict scrutiny analysis. Maybe what they mean is prohibitory laws and punishment are subject, like laws, right, that are punishing association or prohibiting limiting the freedom of association are subjected to a strict scrutiny analysis. To prohibit membership or punish members, the law requires that a person actively affiliate with an organization, knows the organization has illegal objectives, and demonstrates specific intent to further illegal objectives of the organization. And then the right to exclude protected classes, let's just say any class classification of demographics may be excluded if I was saying the association gathers for expression in an intimate association, but not a family gathering, liken it to a family gathering, and the association for expression expression that would be an infringement of rights to require exclusion. I think that there's a bit more to this analysis, but that's a fundamental right. So where we had the state employment expectation, and that more so aligns to a equal protection. So I'm going to put the fundamental right ahead of the equal protection cards, right? Because we're trying to put them in order. Captive audience, again, is another First Amendment sort of related topic. So the First Amendment permits the government to prohibit offensive speech as intrusive when the captive audience cannot avoid the objectionable speech. And this is like radio. Right. We'll put it near freedom of association. These are First Amendment rights. So we could put these fundamental rights in the order of the Bill of Rights, actually. Moving on, I don't have anything written in this Miller versus California current test on obscenity. Put it in that First Amendment section, or I'll put it separate because I know it's now. First Amendment theory is the theory behind freedom of speech is that speech advances like 5 different interests, which is self-governance, discovering truth, hypothetical, advancing autonomy, and promoting tolerance. Each one of these kind of theories of the reasons why we protect speech has its own sort of definition. But I don't have that on this note card. What's specifically those definitions are. Now, here's the O'Brien test of expressive speech. Is conduct that communicates actually the analysis for it. So when you were to be analyzing a rule, for example, that limits expressive speech, which is like conduct, which is like T-shirts that say like really offensive stuff. Say, for example, is the rule or the restriction coming from the state or the government? Producing this state action, like being promoted by the state, because that's required for it to be heard in court, or for rights to be protected against the government. There needs to be a state communicates a message, substantially likely to be understood, and does the law further an important government interest that is unrelated to the expressive speech. Actually, I don't know. Unrelated to the and I ended there. So that's the O'Brien test. And if I'm lucky, I'll have the time to go into my outline, which is probably the lengthiest outline in my possession. Interstate. Interstate is all I have written on this note card. Congress has very broad power to regulate any activity that either in itself or in combination with other activities as a has a substantial economic effect on or effect on movement in interstate commerce alone or in combination have a substantial effect on substantial economic effect on interstate commerce, including instrumentalities of interstate commerce, which is uh, instrumentalities are trucks, trains, and planes. Channels of interstate commerce are roads, rails, waterways, and phones. And streams are stages of interstate commerce, including manufacture, producing, and refining, which I knew. Okay, so that's going to be in the legislative power. Compelled speech is something I don't have anything written on this note card, but I'll hold on to that in case I find it in somebody else's outline. Fair process. In a fair process analysis, the court weighs the timing and scope of the hearing relative to the deprivation of life, liberty, or property. There's 3 parts. The importance of the individual right involved, the value of specific procedural safeguards to that interest, and government interest in fiscal and administrative efficiency, basically. How much is it going to cost the government to have like these departmental hearings for every deprivation of a right, and is that balanced? So this is a procedural due process concept that comes before comes before your equal protection note card related note cards. Fine. which I would say equal protection is like the 14th Amendment. For the most part, and that's what I've got behind this, the freedom of speech. Now, next note part is facial challenge. So a law is on its face unconstitutional as applied to everyone. Pre-enforcement is a word I've been wanting to get out of my notes. Pre-enforcement means that there's no injury yet as applied to everyone. But that doesn't really stop. That's like one exception to the justiciability doctrines is pre-enforcement, where injury is imminent. So where does this go within the context of I think it goes within the judicial branch as part of the justiciability analysis. I think at least this note card specifically here. So, placing it there. Now, inherent executive power. What I have written here is there's four models for the for the judicial branch to let's say I don't even know if it's subject to judicial review, like an exercise of inherent executive power. But if it were, the position of the judicial branch is to analyze whether under model 1 there's just no inherent power, like it's not expressly in a power arising from the Constitution. Model 2, the president can act without constitutional or statutory authority, provided he or she does not usurp powers from other branches' functions and prevent any other branch from performing their function. In Model 3, the president can act unless he or she violates a constitutional statutory provision where the Constitution and Congress is silent unless or until he or she is restrained. And then, and lastly, the most restrictive model would be the president can act unless he or she violates an explicit constitutional provision. I'm sorry, that's the it's not the most restrictive model here. But there's 4 models for analyzing the inherent executive powers. So that's going to go before the judicial branch, but after the legislative branch, as in order of the Constitution. And basically, a lot of this is just interpreting the Constitution, so probably it ought to be ordered in the order of the Constitution. So property is the next note card. Property includes more than personal belongings and realty, chattels, or money, but an abstract need or desire for or unilateral expectation of the benefit is not enough. So, what that means is that expectation of a benefit is probably not enough. Without, more of a property interest, let's say, like not just that you expect governmental benefits, for instance, but that you've been receiving them with the anticipation to continue receiving them. There must be a legitimate claim or entitlement to the benefit under state and federal law. For example, public education, welfare benefits, and continued public employment are kind of where this comes up the most. So those are your property interests. When you're talking life, liberty, and property. And so that's an amendment. That's like the 14th Amendment, really. So I believe, unless I just can't remember these types of things. But what I'll do is I'll put it right next to kind of fair process here. Appointments clause. Congress cannot elect persons to committees with enforcement powers. So that'll go in the